Richard, really good to see you again. And so today, this is a follow-up to the video that we did in our last round on the ongoing consultation, the consultation that just closed at the end of March on refining our competition regime, driving growth and enhancing competition for businesses and consumers. And as we said before, it's a very interesting time for us because we just had the DMCCA last year, which was supposed to be the generational change to the competition regime, and now we're having consultations already on further changes. And there's a few quite significant things in there, so I just wanted to test your reactions to some of these as it's progressed, obviously beyond what we were talking about before Christmas. So the first is the panel model, or the no longer panel model, where I think initially we'd been talking about the idea that within, and again, this is for more complex CMA cases, phase 2 merger investigations, market reviews, that the independent panel, the second pair of eyes, that was the assurance of independence and objectivity and correcting any confirmation bias concerns, was going to be gone, and that it would be replaced with a combination of executives and independent experts. That now seems to have been watered down a little bit in the consultation document, where we will have executives plus some non-execs from the board, plus these independent experts. But the independent experts might be in a majority on these panels as well. So it's not clear. The government's idea initially seemed to be to try to make the CMA executive effectively responsible for the decisions being taken in these cases. But you've got a bit of a compromise here where they will be involved but not have the power to make those decisions. I don't know how you see this playing out.
Well, look, I mean, so what's the big picture here? The big picture historically is that when it came to mergers and markets, the Office of Fair Trading did a preliminary investigation where it thought there was a serious problem. It referred the case to the Competition Commission, and then a new team took over consisting of a panel of 3, 4, 5 expert people with lots of experience, and they made the decision. We then merged the OFT with the CC to create the Competition and Markets Authority. The phase 1, phase 2 model was maintained. But how did you replicate something like this fresh pair of eyes? How did you guard against confirmation bias? Answer: to create within the CMA an independent panel of people from whom 3, 4, 5 would be selected to conduct a particular case, and then by law, they made their own decision independently of the board of the CMA. So, okay, that preserves the old system. Now you fast forward to where we are today. And what DBT is consulting on, it has consulted on, is the proposition that really isn't fit for purpose any longer. And that really the decision should be the decision of the board in some way, because under market and merger cases, it's not the board that makes the decision, it's this independent panel. And that you want to have more accountability of the board, not least in circumstances where the government does give a strategic steer to the board, the CMA, as to what it's trying to achieve. And that seems to me to be perfectly reasonable. Government has industrial policies, etc. It gives a steer. And then the board makes a decision, and therefore ought to have some involvement. Use my words very carefully, ought to have some involvement in merger and market cases. And so that just as with the Digital Markets Competition and Consumers Act, when it comes to digital platform cases designating undertakings as having SMS, the board creates a committee that oversees that piece of legislation. That committee creates subcommittees, so far of 4 people, that make decisions in particular cases, 2 of which will be executive, 2 non-executive. Let's do something similar for markets and mergers. You'd need quite a few people available to participate in decisions in these cases. because there will be more market and mergers cases than there will be digital platform cases.
Yeah.
You scrap the panel, but nevertheless you maintain a pool of industry experts. So one can assume that they will be fewer in number than there are panel members now.
Mm-hmm.
And then when it comes to individual cases, there would probably be a subcommittee of 4 people, 2 of whom could be from the executive of the CMA, 2 would be non-executive. You can then debate who these people should actually be. Should they be non-executive board member of the CMA? Should the CEO be in one of these cases? Details to be discussed in the future. But that's the essence of the idea. And it does seem to me, frankly, that having created this structure for the digital cases, I can see the sense in replicating it here. And let's not forget, when it comes to antitrust cases, where the fines of millions or even potentially billions of pounds are imposed, you don't have a panel making those decisions. Those are decisions of the board. There's delegation as to who actually makes the decision. There's no panel involved in the decision making in those cases. So what you would end up with would be something horizontally coherent across the organisation. No doubt difference of detail, but the basic structure would be the same.
And I guess and this is a concern that I'm sure you've heard voiced by others as well, the differentiation would be in the appeal right. So whether you have a full merits appeal versus a judicial review standard appeal, because the kind of quasi-judicial independence of the panel members was part of the justification for limiting the appeal rights on mergers and markets.
Well, look, lawyers love this stuff. Of course they do. And you hear regularly that the trouble with the merger situation, one of the problems with the merger situation is that there's no appeal on the merits. There's only judicial review, and this is very light touch and very inadequate. Well, I have to say I've become very sceptical of that argument, to be perfectly honest. First of all, if we want speedy decisions, they're not going to be assisted by having an appeal on the merits. It's much speedier to have a judicial review on limited grounds. Secondly, if the CMA in a merger case, it could be a market case as well, but if in a merger case, if the CMA were to reach a conclusion which was manifestly ridiculous, that can be picked up on judicial review. That's a ground of judicial review. And given the expertise of those people at the CAT, which is formidable, the most experienced people in our profession, competition lawyers, economists, but then other people from the government and business or whatever, all of whom have a feel for the subject, they're not going to allow a merger to go through which manifestly should not have been allowed to go through. So to my mind, the accountability is A, of the board to Parliament, and B, in relation to the decision, accountability to the CAT. And I am confident that the CAT will pick up a case which is out of order.
It's going to be interesting. I know there's a lot of heat being generated by this discussion at the moment, but I think the direction of travel, as you say, the government are very clear that they want something to change, and that we are going to see that old panel system gone. And my understanding is that that's something that they are keen to push through into legislation.
Well, I think so, yes. And I mean, when we did that video in the autumn of last year, I said then that this idea, getting rid of the panel for something different, I think it's an idea whose time has come. And the more I've thought about it since, the more I think that. And the more that the conservative legal profession of London objects to it, the more certain I become that I'm right in thinking it's time for it to go.
Well, let's see how it develops. I mean, there's a lot of interesting questions there, but there's other topics I want to get on to.
Yeah, sure.
One that I'm just at a practical level interested in is, and you've been on the board at the OFT, you know how much time is occupied doing other board functions. How realistic is it for the CEO or another senior board member to play that kind of role and really get into the evidence on these very complex cases?
Well, I do think it's important that people that make decisions should be in possession of all the evidence in the case. I think, how many people are on the board? I think it's 9, isn't it? I'm not absolutely sure right now this minute, but I think there are 9 executive and non-execs. So it wouldn't be the case that, for example, the CEO is going to be involved in every case.
No.
And that would not be possible. Furthermore, the reason for having the pool of experts is precisely because it's necessary to have a reasonable number of people. This is quite apart from the independence, but just a reasonable number of people who really can drill down deeply into the case. It's reasonable to say, isn't it, that in a period of 1 year, say, how many MIRs are there underway? Probably
and how many
one.
phase twos? No, it's not.
And how many phase two
cases.
mergers? In recent times, let's face it, it's not that
many.
And especially if the phase 1 remedy setting phase is extended, because that's a different proposal that's being made, that could result in fewer cases going to phase 2 anyway.
Which is in line with this quicker, more
the 4
business-friendly,
Ps.
Exactly.
Yeah.
Approach to doing things. No, I think, well, let's see how that plays out, but it will be interesting. And I think the people who get, if it's still Sarah at the time on their case, that will send an interesting signal, even from the outset. So moving on, another thing under the consultation, which is consistent, is the kind of tightening of the screws on some of the more flexible aspects of the merger regime.
Yes.
So things like the share of supply test, the material influence concept, things which, interestingly, other agencies, including the Commission, have looked at a bit enviously over the years and looked at how they could broaden their powers to get hold of below threshold deals, etc. Minority investments. Now the CMA's, the signal from government is we want more clarity. We don't want these concepts to be as flexible and for the agency to have the power to interpret them in ways which surprise people, which I know they've been criticised for in some cases. Any
My
thoughts
comment?
on that?
Well, yeah, okay. So yes, we have rules that make it easier to look at some mergers than other jurisdictions have. An example of that is the share of supply test, and another example is the ability to look at something that would lead to material influence, which is something less than decisive influence. Let's face it, how long have we had that for? 25, 30 plus years. There's a bit of an element of hubris and nemesis about this, I think, which is that after Brexit, the CMA seemed to flex its muscles somewhat, and it asserted jurisdiction in some cases that did more than raise eyebrows and caused a lot of anger.
Yeah.
And maybe they kind of spoiled their own homework by doing that. The CMA knows that itself, and it spent last year rewriting its jurisdictional guidance. And it has sort of imposed a kind of fetter on itself that it would only exercise these powers in certain circumstances. I personally think that's enough. But the government is asking the question, should we go further and put some of this into law? I don't think it's necessary myself. I kind of trust the CMA to do a proper job, bearing in mind its 4 Ps, one of which, proportionality, includes the proposition that we won't investigate something that somebody else is investigating and can probably do a better job. And I think with
Which is interesting. It's quite a deferential approach to some
well,
of these things.
and it makes sense, and some of those cases it called in actually were being investigated elsewhere anyway. So I kind of wonder whether we really need a legislative change, not least because I know what the legislative change will end up looking like. We'll end up with some, a section 32B little 1 square brackets ZZA square brackets. It'll be horrendously complicated. And what will it say in the end? I think it'll say what's in the CMA's latest iteration of the jurisdictional guidance. So I personally think we could do without it, actually. Sympathetic to the point being made, but I don't think it's necessary to legislate it.
I agree with you. A lot of it is just in the application of the existing test.
Exactly.
And I think the clear message
A
is
bit
that
of
that's being
hubris and a
constrained.
few more P's might be sufficient.
I mean, we've got interesting things like these wait and see cases, which will be very interesting to see if there's actually one where they decide to intervene when the process has finished somewhere else, because I'm sure the parties in that case won't be super happy, but let's see. And final topic, and changing gear a little bit, is the changes being proposed to the markets regime. And this is quite interesting because obviously with the DMCCA we had the new consumer regime, which has been very active since its launch. And we now have the suggestion, again, in line with the 4Ps, that you're going to compress the time frame for market reviews so that the market study and market investigation will be squeezed into one. The time frames will be shorter. But the interesting thing is that the test at the end of the review is no longer an adverse effect on competition test, but potentially an adverse effect on consumers test. So you take the competition element out of the assessment of remedies in those cases. What do you think about that? I mean, that's quite a significant shift.
Yeah, I mean, it is a consultation, and it's floated as an idea. It's not a white paper.
No.
But firstly, conflating the market study and the market investigation phases. I mean, you go back to the Enterprise Act in 2002, and then you get some reforms in 2013, and then you get some more reforms in 2024. It keeps on being tweaked along the way. But the danger is, and this has happened historically on a few occasions, where you have a super complaint that goes into the authority, that's investigated for 90 days, then there's a market study and that goes on for 6 months, then there's a market investigation, and then there's the remedy phase. And various of the legislative changes to date have been about trying to sort of shorten all of this. But even so, with what we've got at the moment, you still have these separate creatures, market study, market investigations, and they have their own rules to some extent. And once you've set off on one, you can't then go off to another. And so the logical outcome of all of that is, why don't we just sort of kaleidoscope the two things together? At first I thought, well, really, is that worthwhile? But now I think about it in an era of 4Ps and all the rest of it, I think it does make sense to do it, actually. I just hope they write the legislation well, because there have been some problems with the legislation in the past, as you know. As to the substantive test, should we be looking for an adverse effect on competition or an adverse effect on consumers? And it is certainly the case that some of those market investigation cases that we've had in the past have been in markets like store cards and home collected credit and PPI and whatever, where there are loads of competitors, but the trouble is that consumers don't look after their own interests properly. You know, economics is how consumers are meant to behave, and behavioural economics are how they actually behave. And so in a sense, some of those investigations in the past were really about consumer problems, but they had to be framed, they had to be articulated within a competition test. And so here DBT is just floating the idea, why don't we say explicitly consumers? I haven't really come to a conclusion on that one. I mean, you could argue that they've looked at what they wanted to anyway within a competition framework. And, you know, in the end, let's face it, in the end, the question in these cases is remedy. Can you come up with a decent remedy? And I don't think the prior substantive test you've applied helps you at all with the difficulty of remedy. And that's because finding remedies is difficult. So I'm not particularly exercised about this one. I'm not sure it would actually make much difference.
I think it's interesting because I know some people have been quite concerned about it, and it's supposed to be a competition test. So you have to be, applying that and drawing from the case law. But I agree with you, actually. I think a lot of these cases, it's not been a neat competition concern, and the way it's been framed has actually been to address consumer problems.
I can see the argument for saying, let's just leave the test as it is. Because the moment you come up with a new test, who knows what, fascinating theories and whatever people might come up with then.
I think, but this goes back to the point we were making before, which is however this consultation comes out, it's how it's implemented that makes the real difference. And that comes down to the steer from government and the powers and approach of the execs within CMA and how that plays out, we will see.
Yes,
but
indeed.
Thank you, Richard. We've covered a lot today, so it was really, really interesting. And I think we're both expecting to have some answers on this in the coming months.
I think they mean this.
So look forward to seeing the new face of the UK competition regime, round 3. Okay, thank you.